promove edição especial virtual. Realização e promoção. Patrocínio. Apoio. Apoio institucional. Parceria. Parceiros de mídia. Assessoria de imprensa. A logística e a transformação digital integrando negócios.
Hello, welcome to yet another day of technical program of our special edition 15 Years of Expolog. A virtual greeting to our audience in Ceará, Brazil, and the rest of the world watching the International Logistics Seminar. And now in 2020, the main theme is logistics and digital transformation integrating business. Let's watch now Panel 7, called Legal Debates. Here are our speakers.
Dear friends, let's start our panel, Expolog's panel, in this year in a very different fashion. We are facing this new logistics and inside informatics, trying to make available for all and to highlight our strategies in a way, not only in Ceará, but in Brazil, in a worldwide fashion. We're trying to adapt to this new way of working, a new way of exhibitions, and it brings us lots of benefits, obviously, but also some constraints. But balancing constraints and benefits, we're trying to build a new era, a new moment, a new world. And within these adaptations, we will try to build a new history. Here in the environment of the Ceará state, we know that we have two ports, and I think development never ends. We are always in front, ahead. We must be always ahead of new technologies to make feasible new markets and bring new job fronts. In our legal framework, in our professional area, that's the theme of our panel today. I think it's important to foster legal debates, and I would like to greet everyone here. Dr. Matheus Miller, our debater, is from Rui de Mello Miller law firm. Dr. Lucas, Rui de Mello Miller, lawyer, and Dr. Osvaldo Agripino is associate of Agripino Ferreira, logistics and trade, foreign trade, PhD in Harvard about port transportation, and Dr. Rômulo Alexandre, partner at APSV Advogados law firm, and Dr. Marcel from Stivaletti. Right, Dr. Marcel? As other associate from Rui Miller law firm. So it's very important to be here together, trying to boost and to enhance and to foster the discussions. As much united we are and talking the same language, and within this legal universe, we may have a bigger development. And I count on Dr. Rômulo. We are ahead of various movements trying to bring development to our state. I would like to thank you, Dr. Rômulo. So let's try to debate and to bring in these debates, taking into account our environment. So we have this organized port, the Mucuripe port, and taking into account we have the same port. It's a different kind of different port, but also in an organized way. Has been doing great achievements to our states, bringing a lot of development. So mostly to agribusiness. So our state agribusiness based on fruits and agribusiness in general. I'd like to bring you some features of our ports with this logistics, and to talk to you that in the case of Mucuripe port, we have integralization with the diverse models, the road and rail and the maritime, and have fishing docks, and we have a commercial docks of 1,050 square meters and 5 berths of docking. We have 5 warehouses of 6,000 square meter each one, with a warehouse of 3,000 square meters. So some features of our Cearás environment, and to give you a good notion of this universe in the Ceará state. I think Ceará is positioning in a very highlighting position, but I think we have a lot to do, and even because the Ceará state is within a geographical area and very favorable, I would say, in front of other ports. Our geography facilitates a lot our foreign trade, so whether east or west, it's a very important thing to highlight in our state. But and I would like to inform you that these logistics debate, they aim to attend our clients or customers and try to reduce cost reduction over these ports for the clients, for the final users. That is very relevant. So in our, it's what we are trying to do with these legal discussions. So and I would like to pass the floor to you, and I would say that it's very important to us as legal operators, try to bring innovations to our clients, try to innovate in this legal framework, and try to help, because many times in our office here, we've been searched to by other colleagues and to try to help with information. So I'm at your disposal here in my state, the state of Ceará, and I'd like to pass the floor to Dr. Lucas, because Dr. Lucas, he has to leave earlier than us, and then I would like to ask you all to pass him the floor, to start. And he'll talk about labor, port labor, and legal update, and the new public policy regarding capital labor. Floor is yours. And we have 15 minutes, okay, for each one of you. If we may keep on the track. Thank you. Okay, good afternoon. I would like to greet you all on behalf of Dr. Philomeno. She is the president of this panel and also the Commission of Maritime Law in the Bar Association of Ceará. It's an honor to me to participate at Expolog in this new normal, this new digital format because of this pandemic. And it's a privilege to me to participate in a virtual roundtable, so qualified with Dr. Rômulo, I'm following his works through LinkedIn. Professor Osvaldo Agripino, reference, Dr. Matheus Miller, a specialist in port law. He's been one of my mentors when I started, when I was a trainee in 2003, and he taught me the first steps in law and then labor justice. And Dr. Marcel, a great specialist in Brazil in maritime law and port law. And I would like to thank you for this kind invitation. Dr. Raquel told about the importance of the Ceará state to the national logistics for the reputation of Brazil in the foreign trade. I would like to highlight the Pecém port importance and also the great work that has been doing by Ms. Mayara Chaves of the dock company of Ceará. And the Ceará, each day more relevant and more highlighting in the foreign trade in Brazil. I'm very excited when we have some space to talk about the capital labor relation report. Sometimes it's difficult to have a moment like that. In just a few events, we have this openings and this open-minded. So when we don't have a synchrony between capital and labor, we have a disturbance in the operators in the terminals and the other stakeholders of the general logistics. And mostly when we have strikes, so we know how much money may cost a strike in foreign trade. And just a correction, I do not represent the dock workers union. I am a lawyer. I am an attorney for the terminal operators. I respect the labor unions, the workers unions, then the federations. But I am an attorney for only one party, the operators. Maybe some mistake in my resume. Okay, okay, doctor. So just Dr. Lucas, just a mistake from our part. Okay, no problem. Just to clarify this situation, I have only one client, so the operators of the terminals. I have my feud with the unions and federations, but with much respect. I would like to highlight these public policies and reforms in legislation about the capital labor relation. I would like to talk about capital labor relation in ports. I think within this thematic it's important to highlight two main axes. One of them is automation. There is an inevitable phenomenon that's present worldwide, and Brazil must absorb this. Otherwise it will be marginalized in the operations we have in Europe. We have ghost terminals, container terminals, the bulk terminals, each day more autonomous and automatic. So autonomous ships, autonomous locomotives, so rail cars. So this is inevitable and it's a process on march, and Brazil must adapt to it. The second point is market reservation of the labor for the port labor, because we as legal operators, despite legal operators, we are very attentive to the market freedom, to the economic freedom to attract investments to the country. So the insertion of the private initiative in Brazil, it's been essential to the port sector to advance in the 90s. And we've had with the law 18630, the open to the private sector to the tenancy of the port sector. So to that moment, the dock companies were state companies, so they've had all the market reservation in this sense. Only them were authorized to operate the ports, and our national system by that time was near chaos. So delayed terminals, lack of competitiveness. So that moment, made very clear that the participation of the private capital, the private sector in the national port sector, as we have worldwide, it's been a watershed and it's been essential to the sector not to be marginalized and outside the global current by that time. And for this, for the private sector to invest in the ports of our country, it's essential to have economic freedom, respect to the free initiative, and we as legal operators, we are very attentive to it. And when regarding the first axis, automation, it's important to have manpower capacitation for this, because labor in the ports will not end, but it will be dramatically modified. So this mancraft work will each day more be reduced, and in proportions, inversely proportional, technical and intellectual work will increase exponentially. So it's very important that the government and all the social actors involved start to face this automation thematic in a more present or accelerated way, in order to the manpower to be capacitated for this. And we have initiatives from the convention from the ILO number states a series of measures regarding this thematic from the 1970s. Here in Brazil, we are very delayed regarding this theme, but in the 1970s, the ILO was looking at this automation, mechanization, and ILO established some guidelines to be adopted to reduce the social impact about the technological evolution in the ports. Obviously, it doesn't state that technological evolution must not happen, so it will happen, and we know about the importance of the port sector for the foreign trade in Brazil. So more than 90%, there's some open microphone, so more than 90% of the foreign trade in Brazil passed through the ports. So without technological evolution, without modernization, we have a great risk for all the Brazilian society, because with a good port system, we have job posts, we have taxes, we have development for the nation. So the ILO stated that we need to have some measures, some behavior. So the retrofit on capacity building. So the mancraft must be prepared for more technical and IT work, or even forwarding of these workers for all other sectors, because we know the port logistics go beyond the warehouses and the terminals and the yards. So incentive to dismissals, incentive to retirement, in an extreme case, the prioritization of the workers of the port systems to obtain new job places within the ports. And why this? Because this last guideline, it's in a scale, it comes after all these measures. All these other measures must precede the prioritization. So, and I include the market reservation. So we have in Brazil, since 1993 law, a very strong discussion about the hiring system and labor binding. And we have two main systems, so the prioritization and exclusivity. I'll quickly explain here the prioritization system. It's that in which when the employer want to bind a new employee, they must offer the job post first of all to the registered workers. And if these workers, they are not interested, then the employer must hire someone out of the OGMO system. So in this prioritization forbids the terminals, the employer, to hire someone from the general work market. So obliged to hire the workers from the OGMO system. So if these workers, they not want to be hired, so we have a complex situation, because bottom line, the operator, the terminal operator, they must assemble their teams to operate, to work. The law assures the right for the operator to have 100% of his staff hired by the Brazilian labor laws with a binding contract. So, but if we have prioritization, and we do not have OGMO workers interested, how can they set up their teams? So this is an absurd. But we're since 1993. We've been discussing this. The 2013 law didn't address this and made it worse. So this is the market reservation. I can now so this is a market reservation of this OGMO system. This is relative or absolute regarding prioritization. I think, first of all, so taking back to the ILO 137, so guidelines. So these guidelines said this. They have the prioritization must be taken into account in a very extreme. The prioritization must be obeyed, but the prioritization must be only taken when we have a strong scenario, crisis through the automation, for example. So the prioritization, it's a special device. So it has been brought to Brazil in a very not so good way, because the law, this 8,130 called the modernizational law, it's been a revolution in the relation capital work. So till then, who detained the monopoly of the management of the sporadic workers were the unions. And we've had absolute market reservation for the sporadic workers on the hand of the unions. So similar to Portugal, for example, and the OGMOs in Brazil have been inspired in the Portuguese legal framework. They've had some management organisms of port management organisms of labor in port. So, but the discussion was to adopt or to not adopt this market reservation. It's been decided between to end with market reservation and end it totally. So they found this OGMO, these organisms to manage the labor force, to have a new autonomous entity separated from the unions to take care of the sporadic workers, and to open a pathway to the port sector to have same reality of the other economic and productive activities. We don't have the market reservation as we have in the ports in other sectors, any other. What we do have, it's the need to pass through a system of habilitation, but not a system that may only be hired workers part of a specific group. It doesn't exist in any other economic activity. So they've created these OGMO, these entities to manage the labor force, and this concept of the prioritization, but in an inadequate fashion, with exclusivity, in a context different from the ILO context, because the ILO context, the guideline about priority was only in an extreme situation after all the devices, other measures, pension and adaptation to capacity building to automation. So it was not the case in Brazil, this prioritization, and it's not the case nowadays. But I understand the intention of the legislator, because we've had a great amount of workers by that time. We've had a great dependency on human muscles So, and then this concept has been brought in a inadequate way, with prioritization way. So, and in another context different from the ILO guideline that was a device for extreme situations. But I understand that it was necessary to establish protection for the normal sporadic workers amount by in that time. But we've so 30 years passed, then a temporary protection, and also this OGMO's role as it's been conceived, because we have another historical step for the OGMOs, what happened in Portugal. So it's been 30 years, and Brazil did not correct, so did not evolve on what we've had in 1993. And we have a constitutional issue, because the exclusivity system, when we constrain a terminal operator to hire the employee they want, the profile they want, including for other example, taking into account gender issues. So they want to hire women to work in operations, so they cannot. They have this constraint with this exclusivity system. So it damages the economic freedom, it damages the constitutional devices, and also the freedom of choice for these workers outside the OGMO, outside the system of hiring, to be hired by a terminal operator. So, and this is in the this is in the ports within the state framework. So in the tenancy between government and private sector, because the private terminals are excluded from this. So it's an exclusivity system that excludes a lot of people. So and there's a possibility to apply this convention from ILO 137 on the private terminals, but this is not feasible because we're not in this context of extreme automation. So there's no need. In second place, the federation and unions, they must decide what they want, because they are so controversial. They want the best interpretation from all the legal frameworks, because they want exclusivity in the public ports and with tenancies with the private sector, and they want also the ILO for the private terminal sector. So they cannot choose the best of the words, the best of the scenarios. But bottom line is ILO 137 regarding the hiring system for the private sectors, private terminals are not applicable. And I will finish my lecture commenting on what happened in Portugal. That took this historical leap. And they had in Portugal the OGMOPs in a very similar fashion, comparing to the Brazilian ones. And then what happened in some moment in the system created to be temporary. So they had the unions and these OGMOPs to replace the unions. And these OGMOPs, they've lasted for some years, and they did in a very correct way in Portugal. And the OGMOPs, they been transformed into outsourcing companies for the port systems. And what happened that the terminal operators in Portugal, they had 100% freedom to hire the sporadic works through these outsourcing companies, and these outsourcing companies competing amongst themselves. So this is a regime that respects the freedom of choice, the economic freedom, the free initiative. We know any monopoly may be pernicious, and including the Brazilian Superior Court in a wonderful auditing by the Justice Bruno Dantas, highlighted is that the OGMO and the way it works. So the market reservation, the absolute market reservation, is a constraint for investments for development on the public ports. And in my opinion, we've been hearing about legislative change, and I think to look at the Portugal experience it would be very nice. The OGMOs must not be ended. They have nice structures, similar to company structures, but we need to end this monopoly. We need to allow that may we create cooperatives of workers, and it will generate a competitiveness gain and development gain, not only for the society but to the workers. Because the workers nowadays, the sporadic workers, they only have the option to work through the all GMOs or to be employees in the private terminal operators. Since we have a new legislation, the OGMOs may turn into outsourcing companies, and they may compete amongst them, and all the workers they will be able to choose where they pay more. And I think the economic freedom, it will be good not only for the companies but only for the workers. Exactly. So bringing these innovations, I think we will have cost reductions, right? And through these innovations, we may have through the legislator point of view, with a more clinical approach, we could unlock lots of litigations we have in the courts, and sometimes it's difficult to mitigate so much demand without a clinical look over these innovations. That I think they're already happening. The legislation must follow what we are working already, the way we are working already. So the OGMO sometimes behave in a very almost stopped, delayed in front of a very internationalized world, and maybe I think it's we have a lack of innovation, lack of a new vision. So it's nice to have a presentation, and if you want to leave now, please feel free, because you told us in the beginning maybe you had to leave earlier, but I am at your disposal in the state of Ceará, and thank you very much. So I am the one to thank you, and I am at your disposal here in the city of Santos. And these changes in the OGMO system will generate the reduction of the Brazilian cost and generate more efficiency in the port system. Okay, so before you leave, just I would like to ask Dr. Matheus, our debater, if you want to bring some question right now or later. Hello, Raquel. Hello. Nice to be with you. And I hadn't have the chance to greet you all and to congratulate you for another Expologues edition. So to congratulate the event planner, Prática Eventos, all the work of the technical committee, because we have an agenda built on the community's feedback. It's a space for our community. And the Ceará State in the last 15 years, Expologue is covering all the content, also with integrating all the logistics, the aerial and the rail, the road logistics, that vision of the triple bottom hub line, the triple hub, digital port and aerial hub in Ceará. And with all the challenges, we are living the 15th edition of Expolog. So to promote a debate after this very clear explanation, so me and Dr. Lucas, we've had the same teacher, the same professor, Dr. Antonio Filho, so the late Dr. Professor Antonio Filho, but we had the opportunity to study with him, and I know Dr. Lucas so for many years, always with this very objective and clear discourse, because he's been following the system for many years. So the first law has been made in 1993, with organizing the relation between capital labor and capital and labor. And Lucas explained in a very clear way all the succession of happenings, and also all the decisions, the attitudes, mirroring nowadays a situation where we have step back in terms of legislation, especially talking about the principle of economic freedom. So it's very clear, we know the history that has been told. Nowadays I have a delayed environment and a outdated environment. So while all the operators, all the terminals, they've been modernized, but labor is delayed in development. And I see this issue about outsourcing companies. We've had this before all GMOs. We've had this port entity, some name like that. So kind of mixed hybrid companies, hybrid entities. That was a great differential. But this history has not been updated, and what I may ask as a reflection, as a takeaway message, and to tease further debates, is that if this reading and also the provisional measure recently approved that transformed into law 14047, if it's been acting straight upon the capital labor relation. So it's been clear in some moment that we've had some points with too much constraints, and during a pandemic moment we couldn't have a regular number. One of the visions, one of the scenarios was not to have a regular number of employees to attend foreign trade demand. And so in an emergential situation, it's clear that this mandatorily or this exclusivity is not appropriate. And I would like to approach this new vision that came with the pandemic. So all the causes of these alterations, and also the consequences and the good experiences we've lived, because we as observers and as legal professionals, as attorneys, we've been following all the development of the capital labor relations within the Brazilian ports. We know that we have interesting examples of interesting experiences, but I would like to let this takeaway message. So the question is the provisional measure converted into a recent law, and that reflects on the capital labor relation and for the future. So the picture of nowadays is from a past, but it's a mirror for a future. So how can we find this harmonization for the future? Exactly, Dr. Lucas. So Dr. Matheus, so a bright comment, if I may say. I would like to thank you, because amongst all the litigations we are facing in this capital labor relation, we've faced the main problems are in the OGMO entity. So these dock workers and sporadic workers, and we face some claims, judicial claims in the courts, and I think this is the main issue on this capital labor relation. And the pandemic, we really must mirror it for the future. And what you stated is very important, because the past will last in the past, but the things are changing to a new way, to a new vision for this work. And I would like to pass the floor to Dr. Lucas and to see what could be a vision about it and to give us some insights. Okay, it's a very important important vision from Dr. Matheus and complemented by Dr. Raquel. So it's the mini port reform. Recently, I would like to highlight two points in this mini reform. We've been seeing the acceleration of some technological tools, not so much used. This, for example, this is not new, but with the pandemic, we've been forced to use more these digital formats already developed. One of the 2 points is the digital lineup, so the web lineup in some OGMOs. They've been implementing this, for example, in Santos. In the last year, people have been reluctant against people that have been behaving against this digital lineup for the hiring process, and this mini port reform reinforced this digital or web lineup, and this is a point that generates economy to us because it spares resources. The bodies do not need to set up a great structure, and for the workers is more economical, so they cannot they don't need to displace from their houses to a port, so they can access the job opportunities through the web. So if he's hired, he know exactly where he will work, and if he's not hired, he'll wait for another opportunity. So I think this is a good innovation. This law reform gave more legal security on the digital lineup. Another point, the recognition that port activity is essential for strike considerations. So during the pandemic, we've had worried about the full stoppage in the ports, and we've had some workers organizing themselves towards a strike. And since we've had this implicit recognition, but the strike law had already gave us a very secure vision about the essential nature of the port activities, but in this last mini reform reinforced the legal security on this, so it didn't finish the right to do strikes, but this is not properly true, but we have requisites, okay? So we need to communicate in advance and to assure that if the workers choose to not to work, the terminals, the operators can hire another workers because it's for the society best interest. So I think this mini reform brought advancements, this electronic scale, the digital lineup, so in the port activity, and then we lack in this capital labor relation reports new law reforms, because as Dr. Raquel said and Dr. Matheus said, companies evolved, workers evolved, but opposing to what happened in Portugal, our source of inspiration for the 1993 law, the Portuguese system developed And then we've stopped to look at the Portuguese system, but we need to look again to the Portuguese experience and to take a leap for the best interest of the port sector. And I would like to just to finalize my answer. So about the importance of the workers. As I said, I have my field of this in a good sense, in the juridical fields, legal fields of the unions, federations of labor unions, but I understand their importance. For example, for the pandemic, so we've had lots of problems in the beginning, but bottom line, the workers, they didn't stop. They've honored their commitments. And as I said, so when when the capital labor relation in the ports works all right, so we have ports, a win-win situation for the ports, for the workers, and for the society. Efficiency, effectiveness, I think that's it. Dr. Lucas, fantastic. Thank you very much. So Dr. Matheus, another question, Well, I'm worried about time, Dr. Lucas' times, and the other panelists. I don't like to make it longer, although it's very useful and it's very pleasant to talk about it. We're talking about a link in the chain and the enormous impact of a mandatory law device impacting in the whole chain, because so we have the speed of, we have a saying that the speed of the logistic chain is determined by the less quick link. So when you have I would like to remember this Superior Court decision that identified as loss of competitiveness, this relation, capital labor relation that we have today. So we understand all the history, we understand all the social reasons. However, we need to look further, and I think this changing, whether inspired in the model, or to be inspired in a model that gives us the possibilities to address these labor issues. I think it's we may go deeper, but I think Dr. Lucas did a very significant contribution to Expolog, bringing to the table this theme with his customary objectiveness and clearness. So thank you, Dr. Lucas, once more. And well, if you will, if you can, if you want, be at ease to leave us, and I am at your disposal. So I'd like to pass the floor now to our next speaker, our master, Osvaldo Agripino. He's a very nice person, so I like him very much. And we'll talk about searching for the cost reduction on the ship overstay, detention, and dispatch. And I would like to pass the floor to Dr. Osvaldo Agripino. So, good afternoon. So, okay, now we are online, right? So, okay, you're okay, technically okay. So I thank you for your kind invitation, all the friends, as Dr. Matheus Biller and Lucas and Rômulo. And well, I would like to say that I love Ceará because my father was military from the Navy, so in the 70s. And well, when he retired, he went to live for 1 year in 73, 74 in Fortaleza. So I lived in Fortaleza near the coast, and I had a surf table. I was 10 or 11 years. I have wonderful memories from that time. And in 2005 and 2006, I've been invited by Dr. Bezerra de Menezes from the International Business Centers I've been for many years lecturing in Ceará. And in one of these travels, I went to Pecém port because Patricio Júnior, the CEO, was a colleague of mine in my Navy merchant Navy time, invited me to know the Pecém terminal. And then I would like to say that this thematic, I would like to congratulate the initiative, Expolog initiative, to deal with this legal thematic and try to harmonize and to align the economy and law sciences to be aligned. Although the most part of our judges, our attorney, they are very skeptical and out of ignorance. I'm not saying they are not qualified. Our judges are lawyers, and they are very qualified. But it's about efficiency. It's about to understand how the laws impact on the port activity, because an international operation, so we have assumptions, we have lots of contracts, or one or various contracts and multimodal contracts. And we have a lot to advance in Brazil regarding this. And about this logistics thematics, about international logistics, where 95% of our foreign trade is performed by the maritime pathway. Almost 100% of our ships are foreign. So we have this article in the Constitution about the dignity. It's because lack of sovereignty on the seas, and that's because that's the reason we have abusive costs, high costs, and I choose an overstay issue about ships and container. And about ships, we have lack of papers or lack of notice about it. I've been consulted by charterers, paying overstay, paying demurrage on the ships. So the demurrage is a compensation, it's indemnization in the English law, that depending on the chartering contract. So the charterer that outsources someone to use their ship. So inside that chartering contract, it's a utilization contract. I have this time regulation issue, and the time for a ship, as for the container, the part of the ship that stays on the docks, it's so important that, so to give you an idea, in our commercial code of 1850, the word stay or overstay were mentioned 30 times. When you talk about freight, we're talking about stay, because stopped ship is a ship without revenue as the container. So that's why we have the demurrage. It's the pre-established indemnization paid by the charterer to those who detain the ship because of the delay in the devolution when the lay time is overcome. Lay time is that period in the chartering contract, as in the term of responsibility to return the container, where the user and the charterer, they may operate without the demurrage charging. And what would be the dispatch? So we don't have dispatch in containers. The dispatch occurs in the chartering contract, and when we have demurrage charging, so sometimes it's the half. It would be an incentive that the charterer would have to receive from the owner when they return the ship before the deadline. So to give you an idea, consultation I've done, so the charterer had to pay $350,000 of demurrage due to the lack of 2 equipment failures on the terminal. These importers from the Paraná state in Brazil, he consulted me about some legal basis to charge someone because he accomplished the civil and the contract clauses. And I said, yes, there are elements there to have to claim against those who caused the delay of that ship he chartered on that port. I would like to call in attention for the Brazilian charterers and the ship users and ship terminal users that the obligation between the container and the ship and the ports are but there's the possibility to pay this pre-established indemnization. They may claim over those who caused that loss. And in Brazil, people do not talk about it. So I've seen from 2 or 3 years ago, we are working on a case like this, trying to claim for the compensation for those who are really responsible. So it doesn't matter who is the responsible, but we need to assess this very carefully, because this is a bill that the responsible for the damage, the responsible that those who are obliged to pay the demurrage on the container, on the ships, because it's a big penalty. Although I've been an attorney of a case of an intermediary agent with demurrage of 1,600,000 reais of reefer containers. And so the dispatcher of the same group of the intermediary agent, they were dry and they were set up as reefer. So they traveled off. So in this legal claim of 1,600,000 penalty fee, judicially claimed. So the value of the cargo was 4,000 euros. So it's another issue we must address. We don't have the choice not facing this. And we claimed ANTAC, the regulator, asking regulator to face this theme. So, but it didn't face the abusive charging, and the legal reporter didn't understand that ANTAC was not competent to regulate demurrage, because demurrage was not freight. So, and if it was not freight, there was no legal basis on the law. And we are in the Superior Court in Brazil, and the Superior Court is asking the regulator to face the theme. So ANTAC recently did a public procedure to economically regulate this demurrage issue over the container. So these are very complex themes. So the regulation is a tool that we incorporated in the Federal Constitution of 1988. That is an interventional way to the state to intervene in the economic domain. And with the creation of the regulator ANTAC, ANTAC is very important as the air we breathe. We do not see the air, but if we lack of air, we will suffocate. So ANTAC, so the regulators are here to regulate electric energy, telephone services, the water I'm drinking, so all the roads. We have regulators for all these sectors, aerial sector. I would like to travel to Fortaleza, but unfortunately I don't have a ticket. So health insurance, so regulation exists for all of this, and it's a technique, a tool to intervene in complex conflicts not duly approached by the market forces. So to think that the market may self-regulate, so I don't think so. We must be careful. We must have economic freedom, as Dr. Lucas said, and we must have an adequate service to have these conditions of fairness, previsibility, efficiency, punctuality. So in this balance, the regulator must intervene. So I'm calling the attention for the sector of the maritime transport in the ports is a sector of a complex regulation because you have lots of players. We have in the container markets the verticalization advancing without any control from ANTAC or CAD with horizontal concentration in the southeast terminals of more than 4,000 points when the tolerate is 1,500 without the state giving a solution for this. So, and we've had a case recently of charging in a terminal based on freedom, more than 5 million reais, and the cargo value was the half of it. So it exists because it's a minimal regulatory intervention option, and this minimum intervention makes the user to pay a lot of money. And if we didn't have the worker, the citizen, the SMEs, the small and medium enterprises, so the regulation in the United States, for example, defend the final user, the customers, so it's linked to the competitiveness defense. It goes beyond the user defense. So we have a debate, and we are dealing with it in another court congress. It's a debate that deals with the new branders. Brilliant lawyer, Supreme Court Justice in the United States, and that made an advancement on the freedoms, but also in the state regulation. And he usually says that it's wrong to think only about the citizen and the final customer. You need to think on the small and the medium enterprises and the workers. So if we don't think in all the parties, we don't have democracy, because we're not dealing with the concentration of wealth. So talking about cost reduction, people do not want to not to pay the fees. People want to pay the fees, but they don't want to pay abusive values. And after they pay, to have omission to be to omit themselves to claim for the responsible. If they may claim against the aduana, for example, with all the forensics, with all the legal process, because the aduana delayed the container, so that importer-exporter is being reckless, because they must claim for their rights. So when we're talking about efficiency, we're talking about a condition for an adequate service that the regulator in the state must regulate, and it's not easy in our Brazilian framework, where we have totally disorganized operation with some exceptions, for example. And people are paying everything without questioning the values and passing the bill for the final user. So it cannot. This is reckless from the importer, from the exporter, from the users. So those customers using services of the concessionaires or tenancies. That's what I would like to call the attention for, and that our indexes of competitiveness, logistics competitiveness, and that's not me telling you, it's the World Economic Forum, the World Bank, and I think the attorneys, they are leaving the claims to the wrong place, that is the judiciary power. our judiciary, so I'm a researcher. I did my Master of Science, I did my PhD about the judiciary system, judiciary impacting in the social development. I've been for a year at Stanford. I have a book published with 850 pages. And so our judiciary systems, our judges, they are extremely qualified, but they are not empowered technically or updated to judge complex claims, because in some development countries they do not take this to the judiciary. They do arbitration or negotiation, and in case of the American regulatory agency, I published this book, my post-PhD book. They have a sector of the Federal Maritime Commission. Lots of the claims are addressed by the administrative law judges in this special entity. So our regulator is improving a lot in a curve of learn, but the improvement is to guarantee that what the Constitution guarantees, so that the service is in the proportional reason. So they're straightly linked in the measure that the regulator may incorporate the demands from the 200 or 250,000 users by a sector regulated by it, and to make those participate in a more balanced condition in front of those organized service providers. And we have another problem that we don't have in the United States. We don't have lobby laws in Brazil. So then the regulator, obviously, with this new agency laws, this power regulator, very close to the service providers, will have more criteria on capacity building, but how could we have a director of a regulator without experience in the sector? This is impossible. It doesn't matter if this director is a PhD or a post-PhD. They must have experience in the market. And if we count the directors of the Brazilian regulators without experience in the market, they will regulate. So, and they tried to bring the public servants from the agency to be directors, but it doesn't address the problems. They must get the best people, the best heads. They must headhunt the best professionals from the market to be the directors of the regulators. So, talking about the container ship demurrage. So, and I can't talk about the effect without talking about the cause. Well, we would pass the whole day here listening to you. So, talking about the abusive fees. So, I am a person who defends the Constitution and capitalism. And capitalism assumes three main basic principles that are in the Constitution. So, the legal security, but with social function. For example, maritime transportation contract with social function. So, hiring contracts with social function. So, we must have this. We must defend the competition, and to defend the user. It's a triple bottom line. So, to assure an income, a profit to the private sector, and to assure the service on the other hand. It's not easy, it's very complex. We've raised the thresholds with the addition of the general law of the regulators, with demanding impact regulatory analysis for result assessment. And I want to see this in our National Congress. For example, for the internal revenue entity, the Brazilian internal revenue entity, to charge the tributes. So in the European Parliament, they do not start any process like that without a proper assessment. So, getting back to the impact about the demurrage about ships and containers, what I would like to state here is that the importers and exporters, in case of containers, and charterers that paid demurrage, they must ask if we don't have any possibility of to claim for at least a part of the fees they are paying for, because if they are reckless, if they agree about the demurrage or the charter, they must pay. Oh, sorry, just to conclude, Professor. So I will finish my speech. I thank you for your initiative. So when you think about costs that are being charged, please analyze the fundamentals, the origins, because I must assure you that a great part of these costs are not duly and they are not just. They may be claimed for administratively and judicially. So, excellent, Professor. Well, we could be here the whole day listening to you because these debates are very broad, and then when we talk about demurrage and mainly these fields that are very linked and all the juridical problems we're facing, Professor Agripino knows a lot. So these problems are very electrifying in our cost chain, and that's make our logistics very expensive. And then I would like to thank you again. I would like to pass the floor to our debater, Dr. Matheus, if we have any questions. Well, I promise to be brief. Also, it's important to interact with our debater, and let's try to search for your insights, Professor Agripino. You give us the energy to keep fighting. So, Dr. Raquel, the theme, it's electrifying itself. It's a very important agenda for the society and for all the links in this transportation chains for the sector to be productive or not. And I surrender to your comments, because we could pass the whole day listening and debating and disagreeing. Why not? From Professor Agripino. But it's a very objective vision that economic freedom only exists in an environment where temperature and pressure are adequate for everyone. So I think the greatest insight is to understand that this is economic freedom, where you have the same temperature for everyone. What we've had before this was a kind of cannibalism, wild capitalism, and so the law of the stronger. So this evolution that Dr. Agripino studied in a very deep fashion brought us the regulatory point of view. So his contribution for Expolog and for an exporter state as Ceará is very significant, and I'm sure that these debates will boost another one. So I have questions to do, but I think we must listen to our lecturers. I like a lot to debate. Please, I would like to pass the floor to our speakers, and if they have questions amongst them, and we'll try to manage the time in the best way possible. Dr. Raquel? Okay, so Dr. Matheus, you talked about these legal debates, and for the first time I would like to congratulate the event planners and all the people, all the staff participating in the event organization. So congratulations for this panel towards the legal debates. It's very important. I've been participating in Expolog and other editions. We hadn't have a panel like this, a specific panel, and it's a unique panel where we can talk about the claims in the judicial framework, and the legal operators must be aligned, around or attend to these issues, and we should open other spaces, and I must highlight that we are in the same environment, getting these debates to the audience, to a very broad audience. Thank you, Professor Agripino. I am at your disposal. I will be here to the end of the panel to listen to our colleagues. I know this. I know you are very passionate professional. Thank you very much. So I would like to pass the floor now to our next speakers, Professor Rômulo and Professor Marcel Stivaletti. I always say your name wrongly. So the lecture is the overstay, charging and demurrage, and the concept of regulation and judicialization. Once more, we're talking about the overstay. As Dr. Matheus said, it's an electrifying thing. So we are seeing lots of claims, lots of debates, and mostly in our courts. In my law practice, I've been defending some clients, and so thank you very much for your presence. I pass the floor to you. Well, Dr. Rômulo, I'm not seeing him. Are you there? Yes, I'm here. Very attentive to all the speeches. I would like to thank you for this kind invitation, to congratulate Dr. Raquel for her presidency over this debate. In 15 years of Expolog, I've been privileged to follow. I think also Dr. Matheus and Dr. Raquel in these last 15 years, acknowledging Cearás behavior in the international agenda. Yes, you are a passionate professional as well. Yes, I think here in our city we make a good team, right? Well, I think Enidi did paid some homage to me, because she know that I started in the foreign trade, but in the last few years I've been working with investments, but my origin is from the ports. I've been listening to Professor Osvaldo, Agripino, and I was remembering in 1999, it was when Ceará used the maize importation as the price regulator, and with the transgenic issue we've been consulting, and in the ports, I remember how we struggled to release the dispatch and to send a ship earlier. For example, the opportunity that something like that could generate in terms of money saving. Well, I'm surely the participants of this panel, they dominate in a more practical fashion the theme, but I would like to highlight something that called my attention. I left the university in 1994, a very extremely important year, because the organizations, Mercosul, for example, the external tariffs, and other economic blocks by the time, and this process of internationalization of Brazilian economy. And if we are not today updated, you can imagine 20 years ago. I remember that before the arbitration law, we haven't had a legal framework about Lex Mercatoria. And Lex Mercatoria is one of the greatest safeguards we have in the foreign trade. So the arbitration law introduces the opportunity of the parties to choose lex mercatoria as a source of law. So we've had a challenge in the last few years to build our internationalization process. So Ceará State has been trying to do this through their ports, through their airports, and looking about foreign investment attraction. So lots of ways to get money from abroad, and this process of transformation presents some challenges, and I will not disagree with Dr. Osvaldo Agripino, but I will bring some reflection about demurrage. I remember the Vienna Convention of 1980. It's only been incorporated in Brazil 34 years later. So the law that talks about will, autonomy, some of the basic assumptions for the foreign trade, delayed 34 years for Brazil to accept the parties' will, autonomy for the right of the jurisdiction choice, the source of law choice. And this is the backstage for the demurrage, so the responsibility in case of default. If we get the English, the Saxon law, they've built the consideration and indemnization concepts, how they've built it. We see the Saxon law that does not admit the possibility of a punishment penalty, but only compensatory. It's been built in a time that you've had a strong social inequality. If you left the parties to establish the consequences of default, they should have they could have a very strong unbalance. But now in Brazil, we can talk about demurrage, about other legal aspects in the last few years. So the defaults, for example, they must be compensated or only a punishment device aiming its prevention. So this debate is in the core. So it seems to me that about demurrage in Brazil, we can admit the two hypotheses, and we have this great tension. So in a very unequal society, or in a society where our port structure, our development structure on the foreign trades did not achieve a certain tier of development, obviously the importer and exporter are paying in these conditions, especially about demurrage. They're paying for the inefficiency on the process. But there's a norm that allows that the contract default may be beyond compensation, effectively saying that for the other party. And I see the ANTAC, the regulator, try to regulate it. So the PL, the project of law, we have a project of law facing this overstayed or container stay, but allows still. I was looking at this law project when it allows that, we must have a provisional contract, but we have this period of time and scale of penalty over the overstay. It will keep the idea to have to keep demurrage, to have penalties and also indemnization. And that's the tension, how to develop a fair process for the various parties operating in the international commerce. So in the Saxon law, you have, so it's an indemnization. It doesn't allow, if it's abusive, it can be corrected, this indemnization. So it seems to be that the courts, they are, depending on the situation, they are kind of biased over a situation or another. But the scenario, I think it's quite addressed in Brazil, because we have these two situations predicted in our legal framework. I've listened to Dr. Osvaldo, but I would like to listen to Dr. Marcel And I pass the floor to Dr. Matheus and Raquel to keep up the good work. So thank you very much, Dr. Rômulo. Thank you for your contributions and for your statements. I'm sure it's a theme that we've been facing in court. In my firm, we have some clients and we have controversial decisions from the judiciary power. We have lots of debates, discussions. We could have taken in consideration that we must balance the losses, right? No one wants to have losses in their ports, and we must try to keep a balance in a way that we may save money for all the parties to spare the final consumer. Thank you very much. Now I would like to pass the floor to Dr. Marcelo Stivaletti. Dr. Matheus, I would like to have the debates in the end, okay? What do you think about it? I would like to only, trying to reunite all the understandings and to have the Q&A, the debate in the end. I would like to pass the floor to Dr. Marcel, Mello Miller Associate. I'm sorry, Dr. Marcelo, I didn't say that you're a member of the Maritime and Port Commission in the Bar Association of São Paulo. I am part of the Bar of Santos, but not part of the São Paulo's Bar. Well, thank you for your presence. And where are you? Are you there? Okay. Now you are online. Thank you. So the floor is yours. Thank you, Dr. Raquel. So be my guest to our Maritime Port Commission in the association, the Bar Association of São Paulo. So I know him. He's a fantastic professional. So I would like to thank you for your kind invitation. I would like to congratulate all the organizers and all the creators of this event, traditional event, and I would like to congratulate your conduction. Congratulations for your work. And well, I cannot forget to tell that all of you, my panel colleagues, are references, and I am the last in the line, so I almost have nothing to say, but I'll try to bring in my experience about this overstay, container overstay. When we talk about these containers overstay, we talk about remissions. We're talking about remissions, the claims over trying to get the money. But when we see in the decisions from the judiciary, quite shallow decisions, and we experience in this moment that the sectorial entity participating more actively and tech laying over the themes. And our audience may ask, well, don't we have parties will autonomy over overstay? Since we have the pillars, contract pillars, obey it. It's a business, legitimate business. It must be respected. But we have a public interest, and we have the regulator, ANTAC, and the ANTAC, the regulator, does this under the law 10,233. We have the we cannot neglect the public interest. We have this law 10/233 and its item 4. All the UNTAC is responsible to elaborate norms and regulations for the aquatic transportation through port and aquatic infrastructure, assuring autonomy in its accesses and assuring the right of the users and boosting the competition through operators. So UNTAC starts to work this users bias, this users framework. We must highlight it. It must be highlighted. We have an important paradigm, the normative resolution number 18. This number 18 normative resolution dedicates an entire section about container stay. It showed by that time that numerous entities, representatives, and administrative claims arrived to UNTAC. And what do we observe in some situations? For example, to give you a very specific example, we have some periods where we have the increasing in the charging. So we have the free time and we have the second stage, and from the second stage we have an imposition of some value, some charge, and the last period of an even higher value. We have UNTAC forbidding the charging in the free stay stage. Sometimes UNTAC intervene on this through the resolution number 18, and it forbids in an article so to forbid the charging over the container stay in the free stay stage. In detention, for example, something that we observe sometimes. So the detention, it is the overstay that over export. Sometimes the user, they deliver the container to be shipped on the terminal. The cargo is cleared and free to go. And sometimes in this moment we have the charging, so UNTAC forbids this behavior and with the proper penalty. And this is forbidden because from that moment the shipper has no more possibility to act over the cargo. So this and other issues that are debated everywhere and much more. They've created, as Professor Agripino said, they've caused public consultation from UNTAC. So these contributions, they will be priceless for the segment because UNTAC gives voice to users, an important party, and also to the transporters. Till when we can charge, which values these between stages increasing. So let me give you a concrete example, a case in which we worked on. In the first stage, $65 of charge. In the second period, $96. In the third stage of the overstay, $140. We observed in this case an increasing between the first period and the last stage, first stage and the last stage, of 112%. So this kind of occurrences, they flow to the regulator, and the regulator must lay over this to find an adequate equation, and most of all, about the amount, the duty amount. As Professor Agripino said, because of only one container, we have an astronomical value impossible to play. And nowadays, our scenario is we keep judicializing, no doubt, but technical field starts to borrow its participation, and consequently, we as legal operators, I am a professor, as Professor Agripino says, we need to boost the sector amongst the judicial claims. Why not? Because if I understand charging far from the reality or disobeying the market standards, we must activate the regulator, or maybe to work administratively on this case. We are legal operators and we are debating, we are talking about possible scenarios, right? So what is the core of all this discussion, passing through judicialization, arriving into the regulator, and with this public consultation, very important for this segment, because I can tell that the voice is not only from the users, also the voice, the transporters must be listened to work better. And what is work better? So work better is to have a fair price and an adequate service providing. This public consultation aims to assess a safe criterion of methodology to find the charging abuses. And there's something that we must, because we are legal operators, to be attentive to, and also to deliver our contribution. And we hope that by the end we have an equation that considers a fair price and the best service providing. I always state that it's not forbidden to the shipper or to the ship owner to charge for. It's totally the opposite. They have their containers and their ship to work with and to act as merchants or as businessmen. But we have a technical entity, a regulator, that must assess with this public consultation that amount practiced is normal, is within the thresholds or not. So no one better than ANTAC with its technical staff studying a lot to deliver this equation properly set up. And we as legal operators, we must tease the regulator entity to understand its role and to boost and to act whatever through the necessary measures to find, I reiterate, the fair price plus the adequate service providing. And I think about overstaying, I think that's my experience, and I'm at your disposal for everything you need. Thank you very much. Oh, thank you, Dr. Marcel. Thank you very much. Important reflections. So, in taking a little bit of each one's speech, I think each one of you stated leveraged in our environments, in our daily routine. So all we want to generate competitiveness, efficiency, effectiveness, and try to bring to the ports what they need to address. And in the legal tier, the legal framework, we need to go deeper, go further, and to be ahead of all the issues. Dr. Matheus, the debate is yours. Okay, I think the theme, it's very interesting, and our current situation makes it even more interesting because I have a division of judicial sentences, so the judicial power. Sometimes in certain states, in certain jurisdictions, in the first or second degrees, they have these different sentences, and also in the superior courts. So it brings us the thematic relevance of juridical debate. So it's an agenda that touches, bottom line, the consumer, the producer, the country developer. So its relevance is thematic, but the point of debate is the interpretation. It's the different interpretation. It's not an harmonized concept. And I will start our debates with each one of you, because Professor Agripino he talks about demurrage on the ships, and it's very interesting to search for the etymological origin of demurrage, and you find bases on the ancient French, and used for the overstays or going beyond the ships, going to rail cars, renting, for example, the chartering. So what Professor Agripino brings us, it's the origin, and with the invention of the container, where the world logistics gained a lot. And so the details, the minute details of that operation. So, and who's the container? Who owns the container? And who owns the freight? And I have a contract where I negotiate or not negotiate. So these minute details over the contracts, they been raised over time. And Professor Agripino, Dr. Rômulo, and Dr. Marcel, they have this point in common, that so judicialization is not the adequate jurisdiction. We are taking claims to where we can, but we shouldn't, because it's a matter that needs fact knowledge, historical knowledge over the fact, because it's the agencies performing to know about the port facts. As the Professor Agripino said, the agency in developed countries, they have market experts directing the regulators. And so nowadays we have judicialization. We are as a decision jurisdiction, but we have an agency trying to balance, not as a blind justice, but as a knower of the economic facts. I think it's very positive to explore in this moment something over these controversies, and on this interest from the agency to bring new information, because it can create procedures to eliminate some practices, that constant information about the safes, leaving that to the end, or some evolution, but we understand some debates. Not to establish the points of our theme, I would state the visions from you. Okay, we're talking about indemnization or criminal penalty clause. If you think about ship owner, logistics chain, the empty containers necessary for them to the next client. And so it's a logistic chain, and the dock and the ship owner. We need to consider this. But it's also a penalty, that criminal penalty, that maybe I'm not responsible for. so that delay in returning the container may not be linked to the service buyer. So, and maybe Professor Agripino can comment with this look. It's more broadened look. Okay, thank you, Dr. Matheus, for your considerations, and we need to run a little bit because for the sake of time, okay? So, Matheus, thank you for your comments. I'll get your comment, and in some way, also comment Dr. Rômulo's and Marcelo's ones. So this legal nature for the judge and for the regulator and for the user themselves are not, this is not the main issue. The main issue is to have a fairness that is a condition. Without fairness, to the fair price, in the American legal framework, they call it integrity of tariffs. But tariffs are sometimes translated wrongly into Portuguese. Well, but a tariff that makes available to the service provider to charge 80, 60 times the cargo or the freight value is a price, it's a fee that in my point of view is unconstitutional. So it's been a discussion we've had inside the Superior Court and inside the Treasury audit entity. So we think that the judiciary power is interpreting wrongly the demurrage, because the judiciary needs from the regulator a normative. So the maritime operator has the thresholds for their risks from the civil code and from when they do not have the knowledge about what they're transporting is what we have. So we have this device in the multimodal legislation. So the maritime transportation, they already have during their service providing these. So one of the reasons we've taken to the Treasury auditing entity, it's called TCU, about abuse of charging. So the violation of isonomy of the risk management in front of the user. So the user, the existence of contract freedom. There's no contract freedom. I have never seen a user to disagree with the demurrage value imposed by the ship owner or by the cargo agent. I've taken a case to the TCU, the agent that charged value demurrage in a reefer container in the import $300. The Japanese ship owner charged $60 per day with free time, and in the Brazilian conditions, no free time allowed. So we have coercion. These terms are nude, considering the legal basis. If there's no negotiation, it's like the ship owners and the cargo agents, they practice the table of prices. And I have lots of reasons to make the TCU to go towards ANTAC, demanding the regulation, because this is causing bankruptcy in the small and medium enterprises. So you're saying that the value, a judge told me that the value, you're telling that the value of demurrage is too much high, right? And the judge, so the value is indeed abusive, but I don't have a norm, but I would like to reduce it, but I don't have thresholds. because the parties will say that I'm reducing too much or too few, depending on their point of view. Because we have terms here, we have a contract here, the client sign. But so the regulator must intervene. Otherwise, the regulator is not accomplishing its constitutional role. So there's not adequate service without fairness of prices, of tariffs, prices and fees. When they created in 2001 the law that created UNTAC, and when they stated about fairness, they didn't need to extend 60 kinds of fees. We need to have price fairness. So obviously we have lots of obviously we need to have thresholds. There's no freedom without thresholds. Obviously we must discuss it. Technically it's not simple, but that's what it's on UNTAC's lap. The Demurrage, the normative resolution 34, we have a claim and with UNTAC about this. There's no, so the up thresholds of markets, free initiatives, it's proportional to the market that want to be capitalist. It's proportional to me having a car and paying a tax for having this car. We need to have on the regulator framework this. Obviously, exceptionally in front of an abusive case, because the model is ex post, it's not ex ante. In China, you can't provide a service and charge nothing without informing the Chinese regulator. So the law project must be registered. So in this public consultation, we established this. Recently, we don't want a term of responsibility. So we need to establish the price of the daily fees. Must be the ship owners, not the cargo agent, as in the United States, in China. So when you take off the intermediate, you help a lot. I will not go further, but I would like to state this. So the contract freedom is fake reason. So in the demurrage contracting on containers in Brazil, there's no contracting. There's no freedom. If the aduana dispatcher do not sign, so it's not the cargo is not cleared. It's a crime of fake identity. Sometimes the ship owner does not clear the cargo on the system, saying that did not pay freight, but in fact it's a demurrage because it's illegal, it's crime. So I wrote a book about it, about demurrage. This is I'm an attorney. Oh, there's a Professor Jean-Pierre, an Australian, that worked for the ship owner. So Brazil is a point out of the curve. We have more claims about demurrage than in China. So the judiciary is not empowered. They need some norms, and the regulator must create this norm, discussing with the community. I think these regulated agencies must not be in Brasilia. They must be where the market is, close to the university, so the agency directors would not participate in Ministry of Infrastructure ceremonies to sign law projects without regulatory impact assessments. This is not correct. So this is another discussion. We're talking about demurrage. I participated a lot on the normative resolution. The normative resolution is one of its conclusions. It's on page 339 in my book, in 2007, 2008. We are on a pursuit. We have had a technical discussion to have thresholds on the demurrage. ANTAC is performing this debate, 3 years delayed, but it decided before that it was very complex, but the TCU now is giving the regulator some pressure. I think we have a possibility to have a norm that when it's judicialized, the judge may have a possibility to have a legal basis to establish the upper threshold. That's it. Thank you for your time. So I'm very grateful to you by your contributions once more. Excellent reflections. Obviously, we have lots of bottlenecks in our legal framework, but we need to face them in a way or another. And that's why it's important, and I would like to congratulate you all. Once more, to congratulate you. We are arriving to the end, almost ending our debate in our panel. Dr. Matheus, do you have any other thing to highlight? If you will, so I would like to highlight the importance of being together, the importance of being leveraged and aligned with the same way of thinking, sometimes disagreeing, but how important it is to reflect, to evolve, and this evolution brings innovation. And that's what we are living, we're passing through innovation, and we need to reinvent ourselves a lot. Obviously, the users must bring these innovations as well, and the legislation must follow all of this. I would like to open the floor for the final remarks. Okay, let's let them do their final remarks from all the things they've said, Dr. Rômulo, Dr. Marcel, and then our final remarks. Dr. Rômulo, please. Oh, I think we are out of time, but I would like only to thank you. It's been very important to listen to. Well, I have a quite liberal perception over some aspects, but I think Dr. Osvaldo's Agripino statements are important, trying to regulate a market, an unregulated market, but not always. The state's power is not always necessary to address our conflicts, taking from us the power of decision, but I think it's an excellent reflection. I think Dr. Matheus, Raquel, and Marcel and Lucas left us, and I wish we may be together in the next opportunity. I think your microphone, Dr. Raquel, is muted. Okay, thank you. Dr. Marcelo, final remarks. The floor is yours. So first of all, I'd like to thank you, Dr. Raquel, for this debate, for this wonderful debate. It's very important to listen to all these references in this passionate means through which we advocate, and it's our duty to boost and to highlight these debates, and I think this event, Expolog, made this, with excellence, and congratulations also to your commission in your bar association with your leadership. I think there is some hope. I'm hopeful because on one hand, we have some people saying that we have excess of regulation. It's not my feeling. I think the regulation is quite shy, and we need to enhance it. And I see we have a clear pathway. We have a pathway being built. Debates like this shows us that UNTAC is working on sensitive themes. We talked about this container issue. It's very passionate, but we have lots of details to be observed, whether on judicialization, whether on the regulator. So my final message is that the regulation is walking properly. I think we have a good horizon, and I congratulate you for the high-level debate. And thank you. Well, thank you, Dr. Marcel, for your contributions. And now I'd like to pass the floor for the final remarks. I'll be very brief, because I liked a lot Rômulo's statements. I would like to tease you because I think we all know the characters here. We all advocate for the economic freedom and for the decreasement or decreasing of the state on the conflict resolution. I think we share this vision in common. But I think when a claim searched for the judiciary power, the claim asked for the state intervention. But I think we need a more technical body, as we have technical bodies or regulators over oil, water, energy. And I think we do not have excess of regulation. I would call it a good business environment, only with an observation that we share the same principle. And I think this is a very important point till when we have a balance, because it's very important for a country where we don't have a healthy environment, an equal environment. You do not have this balance, using the sport jargon, that we may have a balance, not a political balance, but a technical balance. And I think we need to save maybe the SMEs from the justice, I think I would say. And that's my final remarks. I will not. We're all prepared to bring the Expoloc audience the most interesting legal debates from nowadays. Dr. Rômulo, thank you for rescuing your past and foreign trade. And that's why you are the excellent lawyer and attorney and consultant. You are Professor Marcel, Professor Agripino. It's much important to have you, productive and prepared professionals, because you were a light beam for our sector, So people like you make the themes to be relevant and to be highlighted properly. And thank you for all the Expolog team. And Raquel, the floor is yours. Thank you, Dr. Matheus. Thank you for being our debater and to bring on the table these questions. And the debate is really important when we approach truly and we try to incorporate the debate to our daily routine. Well, I hope we have good winds indeed, because when we go deeper and further, when we have these strong debate moments where we share our understandings, our positions, and then we discuss them, and or we change opinion, or we change our minds, or we leave the debate even stronger, and that's what we need to boost our environment and to bring innovations to our sector. So to me, I'm very enriched for being here with you, and I would like to congratulate for the Expolog for this thematic, and we need more. I would like to congratulate the event planner, Practica Eventos, and also my colleague in Ceará, Dr. Rômulo Soares. We've been teaming up to face lots of challenges. We've had lots of important moments together, and also to congratulate Dr. Osvaldo Brazil, Dr. Osvaldo Agripino. Our association is making history in Brazil, and I'm at your disposal. I'd like to pass the floor to Osvaldo Agripino, the last 2 or 3 moments. No, I think less than 3 minutes. I would like to thank you for your invitation and say that we need to debate. We must, the regulators will be demanded to level up their technical thresholds because we have people studying more, we have people demanding for the regulatory impact assessment, so the level of the thresholds are improved. So the judiciary, as we stated, must be the last place to be searched for. That's why we put the legislator in the 90s starting to create the regulators, and they created, amongst others, ANTAC to help we to have a better environment of business, more competitive, everyone earning reasonable incomes and fair prices, with the cargo being treated well, with dignity, so the service providers with dignity. So the regulator must work to avoid abusive prices, and to avoid abusive prices, the norm must be ready. We don't need the problem to be put to the judiciary, and the judiciary without the proper capacity to decide. And I think we are advancing. I'm very optimistic, although I'm skeptical on Brazil, but I did not give up yet. It's a struggle, it's a difficult fight, but if we converse, if we dialogue, if we diverge without hate, on the contrary, without much love, I think we can put Brazil in the place it deserves to be. Thank you, my dear colleagues, and let's watch the 15th edition of the International Seminar on Logistics, Expolog. We have lots of panels, lots of interesting panels. Please subscribe and watch us. Let's try to innovate each day more, bring in more innovation to our sector. Thank you very much. Thank you all.